Now I get to introduce Ming Shui. And Ming Shui is a primary patent examiner at the US Patent and Trademark Office, the USPTO, and works out of the Silicon Valley office. Prior to joining the patent office, Ming was the corporate counsel at Amazon.com. He practiced patent law at the firm of Baker Botts in Dallas. He clerked for the Honorable Howard McKibben of the U.S. District of Nevada, a graduate of the University of Michigan Law School and the University of Nevada, Reno, with a degree in engineering physics. It's a pleasure to bring you into our webinar family today, Ming. Thank you for joining us, and please take it away.
Thanks, Kelly. Thank you for having me. I appreciate the wonderful introduction. As Kelly mentioned, I'm with the United States Patent and Trademark Office, and here to give you a quick overview of intellectual property. I noticed on the poll that a lot of you were most interested in finding about patents and trademarks, which is great because that's what our office does. So it's there you go. There's the screen. So let me go back. Sorry, a little lag on the computer. So sometimes these are the slides might be moving a little faster than or slower than I expect. So who are we? Well, the USPTO is the federal agency that grants U.S. patents and registers trademarks. And we also advise the president and federal agencies on intellectual property protection enforcement and promote stronger and more effective IP protection around the world. So we're kind of the agency, sort of the go-to agency in the government that sort of tries to help set intellectual property policy for both the United States and help the U.S. set its priorities for across the globe. Our mission is to foster innovation, competitiveness, and economic growth through the use of patents and deliver quality examination for patent and trademark applications, and also deliver educational resources to the public about about the patents and trademarks that are available. And it's part of why I'm here today. So what is intellectual property? It refers to creations of the mind, such as inventions, literary artistic works, books, movies, things like that, designs, symbols, names, and images used in commerce. So a lot of you answered that you don't actually have any intellectual property, but I think you'd be surprised to learn that probably most of you do if you're a small company. If you have a business name, that would be considered intellectual property, even though it hasn't been registered. You do get some what are called common law trademark rights to your business name. So you may already have a bit of a trademark and you don't even know it. And the same thing with copyright. Copyright attaches automatically to any work that you've designed. So if you've done a user manual, or if you've sort of written up certain things that relate to your business or things that you do, you may have a copyright in that, because copyright attaches automatically to works that you've created. So all of you that answered no, you may be surprised that you actually do own some intellectual property. Despite not actually having registered with us or filed for a copyright registration or filed for a patent. So just to give you an idea of how patent growth has gone over the years, you can see that in recent years, it really has grown exponentially, and patents are becoming a more important part of the business landscape for businesses, and it becomes potentially more important than ever for you to really consider protecting your inventions with getting a patent. So why should you care about IP? You're a small business, you're looking, why does IP matter in terms of your business? Well, it's attractive to investors and buyers. If you've ever watched Shark Tank, one of the questions you often hear is, do you have a patent on it, or have you filed for patent protection? It's definitely something that investors do look for. when they're considering your business. It deters infringement lawsuits. I can tell you just sort of from experience that it's always helpful to be able to hold up to a jury your patent and say, this is what I do. And that a lot of times makes juries think, well, you know, if you have a patent on it, then you probably aren't infringing somebody else's patent. Now, that's the rest of that is more of a gets into more legal advice that I can't get into, but it certainly does help if you are ever faced with an infringement lawsuit. It increases leveraging power in your mergers and acquisitions because intellectual property is valuable. Patents are worth something in terms of both protecting your brand, in terms of protecting what you do and your inventions and what you make, so that somebody who's looking to potentially acquire your company knows that somebody can't come along and just simply copy it. It is very much a property right that adds value to a company, and certain types of intellectual property are also global. Patents, unfortunately, are not one of them. They are a country by country thing, but trademarks and copyrights are often much more global in terms of their reach. So how do you develop your IP strategy? Well, first thing is, look at what you have and prioritize. Do you have your patents? Do you have your trademarks? Have you filed for your company name to make sure that nobody else can be the source of your goods, or to identify a certain good that you do make if you have something that's that has a creative name for it. And think about what you need. Do you need patent protection? Is this an area where there's a lot of innovation and people look to enforce patent rights? Or is this maybe an area where you have a competitive advantage for something that is kept secret? And we'll get into trade secrets in a little bit. And figure out what is most important to your company. What are the areas that are the core functions of your company that are crucial? And those are the areas that you want to really consider intellectual property protection on. Know your competition. What sorts of protections do they have? What sorts of intellectual property do they have? And how would you go meet the challenge? The same thing with the pace of innovation and opportunities for growth. If it's a area that there's not a lot of innovation going on, and maybe if you do have the opportunity for growing in that area, and it would be worth seeking patent protection because you are coming up with things that are new that could potentially revolutionize an area. Determine the best way to protect your IP. That goes right back to strategizing about what sorts of protection you need and where you want to go with it. Develop a plan, set goals, and implement. And just like in any other business project that you do, and ask for help. Certainly, we're here to provide the basics of how to do intellectual property. Towards the end, you'll also see some resources that the USPTO does have to help out small businesses and solo inventors as to do so. But ask around and see what sort of advice you can get in terms of figuring out where your IP strategy should go. So what are the types of IP protection you need? There are really four main types. There's the patents, which protect inventions. Trademarks and service marks identify a source of goods or services, so that's more like a brand. Copyright basically protects artistic works and expressions of ideas. And trade secrets protect things that give you a competitive advantage but just aren't known generally to the public. And there are pluses and minuses to using each type of IP protection, and we'll go over that very shortly. So here's kind of the overview of intellectual property. You'll see on this chart that there are actually two types of patents. In general, we'll be talking more about utility patents here rather than design patents, but just be aware that there are actually two types. The utility patent is the most common patent and the thing that most people think about when they hear about patents. And that's when you have an idea, you've come up with something new, and you want to be able to protect that invention. So examples are like an iPod, a chemical fertilizer, process of manipulating genetic traits in mice, just and pretty much anything that is an idea that you've made or can do, or a process that you can do is protectable under a utility. And that goes from 20 years from the date of filing of the regular patent invention. A design patent is slightly different than a utility. The design patent protects the ornamental look of an object, so sort of the unique shape or the unique design of something. And so if you kind of think like about the unique shape of a Coca-Cola bottle or things like that, those could be protected by design patents, and those are good for 15 years from the date of issue. Copyright is what I think most people think about when it comes to artistic and creative work. So your books, your movies, your films, and all of that. And copyright has a much longer term of protection than patents and trademark and than patents generally. It's the life of the author plus 70 years, and there's some other terms for different works, but we won't get into that. Trade secret is actually something that is confidential, a method that you use, something that you do, and it gives you a business advantage. So if you think about the Coca-Cola formula, the KFC herbs and spices, things like that, those are trade secrets because people don't know about them, and it is something that gives you a business advantage. And that lasts for as long as that information remains confidential. So basically, you do have to take steps to keep it as a trade secret. A lot of times, you occasionally hear things about secret barbecue recipes, and that sometimes people say, I can't tell you because I have a patent on it. That's actually the opposite. If you have a patent, you have to tell me. But if you have a trade secret, you don't have to tell me. So it's something that's kind of interesting. Lastly is trademarks. And those are words, symbols, logos, designs, or slogans that identify and distinguish products and services. So if you think about a company logo, a company name, product names, those things are what are protected by trademarks. And one of the requirements for trademarks is you have to use it in commerce. And it's good for as long as it's in use. So like trade secret, trademarks can actually last forever as long as it's in use and you continually use it in regards to a company or your services or your products. So you can imagine there's actually a lot of IP in a mobile phone. And this is just kind of a slide that sort of shows you how much IP can actually just go into a product. You've got the trademarks, like Nokia and Microsoft Windows. You've got patents related to all the circuits in the phone and all the electronics. There's copyrights on the software and the manual, potentially to the ringtone. You wouldn't know what the trade secrets are because they have to be secret. And you can also have the design, so sort of the form of the phone, the arrangement of buttons, things like that. So there's actually a lot of IP out there that you may not have considered is actually IP. So because we're the Patent and Trademark Office, this is going to focus a little more on trademarks and patents. So what do trademarks offer? Well, they offer brand recognition. Again, trademark is essentially your brand. You have a public notice of ownership, so people know that this is you. And you have the right to enforce it nationally and bring legal action. So if somebody decides to copy your business name, you can potentially stop them. Certain things like the use of the federal trademark registration symbol, the right to record with customs and foreign filing and publication in the U.S. database, or other things that are probably not terribly important to small businesses currently, but just be aware that there are other rights that attach to trademarks more than just sort of your brand recognition. And I'll give you an idea of just how valuable some of these brand trademarks are. You can see that Apple's branding is worth 170 billion, and Google is worth 120 billion, just sort of on their branding and name alone. So just to give you an idea of really intellectual property, even just in trademarks, it can be worth quite a lot, especially if it's a very recognizable trademark. So what is a patent? Well, it's a property right, and what it gives you isn't the right to make your product, but it gives you the right to exclude others from making, using, selling, offering for sale, or importing the claimed invention. So basically, it really is a right so that you can stop somebody from copying you. It's for a limited term, and it is territorial. So if you file a US patent, it's only good in the US. If you need to file overseas, you'd have to file in the countries that it would matter for you. Unfortunately, there is no worldwide patent. So why do we give you the right to keep somebody from making an invention? Well, we want to make sure that the investment of your time and money is rewarded, and so that you can keep coming up with new inventions and coming up with things to improve upon what we're doing. In return for that monopoly, what we get from you is you tell us how to do it. So that helps other people learn from what you've come up with, and help other people essentially make improvements upon what you've also come up with as well. And so that helps accelerate the development, so people aren't trying to reinvent the wheel all over again. And it is actually a very big part of our national economy. So when should you file? And this is pretty important. The United States is a first inventor to file system. So basically, whoever files first wins. This was changed in 2013 from a first to invent system, more to harmonize with the rest of the world. In general, if you're looking for international protection, you do want to file before you make any sort of public disclosure, and we'll get into what public disclosure is shortly. If you only want United States protection, you can file within 1 year after your public disclosure. But again, because we are a first to file system, it's pretty important that you should file before you do a public disclosure. So what are the risks, and what is public disclosure? I'm gonna kind of go about this a little backwards. So examples of public disclosure are displaying your invention at a trade show, posting it on the internet, offering to sell your invention, publicly demonstrating your invention, things like that. So if you have an idea, be careful about where you present it, because that could potentially affect your rights in terms of getting a patent. So what can you say? You can talk about your invention potentially at a high level, but you can't but if somebody could learn what we call how to make and use your invention, then you've probably said too much. And the same thing is like with a disclosure versus sale. So a lot of times people do things like Kickstarter campaigns or Indiegogo. Just be aware that that could be considered an offer to sell, and that could affect your patent rights. And can you just keep it a secret? Well, sure. It's entirely possible if it's something that you're not selling, or it's a proprietary process or things like that, that you are able to keep as a secret and treat it as a trade secret. But that's just something that is really something you have to consider on a case-by-case basis as to what your invention is. So how does a patent work? Well, you come up with a new idea. You can file a provisional application, which basically holds your place in line. It sets a date for when an examiner like myself, who goes to look at whether what you've come up with is something new, that sets the date for anything before that date I can look at, but anything after that date I can't look at. But you have 1 year from the filing of a provisional to file a non-provisional application. And that lets you sort of make your disclosure on the provisional and decide whether or not it is actually worth potentially going for the non-provisional. And then you have 20 years from the filing of the non-provisional for potential patent protection. So why should you file a provisional? Well, it's one of the biggest benefits. First is that it holds your place in line. So that sort of stops the clock and potentially gets you ahead of other people who may file regular patent application after you filed your provisional. It's also a lot easier, and actually it's a lot cheaper than filing a non-provisional. So there's simplified filing requirements. You don't have to follow the formalities of the actual patent application. There are times where I've been up against deadline and we've filed things such as software manuals and user manuals for things just to get something in place. So it doesn't have to be a formal legal document. Things that are required are specifications. So something that clearly describes your invention and how to make and use your invention so that somebody of what we call ordinary skill in the art can essentially copy your invention. But that's why you get the patent, to prevent them from copying the invention, but you have to disclose to us how you do it. That's sort of the trade-off on the patents. So it's the same disclosure requirement as non-provisional, and it has to be enabled in written description, which is kind of what I just went over. You need drawings. They're almost always needed. So show us what it looks like. Give us overviews of how things work, how things are put together, things like that. The thing about a filing fee, and the thing about a provisional filing fee is that it is significantly less than the non-provisional filing fee. So you can file a provisional for, I believe, if you're a microentity right now, as low as $70. That changes. That does change regularly, so I'm not 100% sure of that. So check it, but it is not actually a significant expense. And a cover sheet identifying a provisional application, which you would get when you file, if you file it online, that's filled out for you as part of the paperwork that goes into getting it filed. So what resources do we have for you to help out with your patent applications? Well, we have what's called a patent pro bono program, and it matches financially under-resourced inventors and small businesses with registered patent attorneys. And in California, the organization is the California Lawyers for the Arts. And basically, if you meet the qualifications, you may be matched with a patent attorney who will essentially draft the patent application for you. You're still responsible for the filing fees and everything, but generally, in terms of a patent application, the attorney's fees are often significantly more than the fees that the patent office charges. We also have a law school clinic certification program. And what this does is it allows law students who want to become patent attorneys to draft up applications under a supervisor who is allowed to practice before the Patent and Trademark Office. And essentially, you're helping students learn how to draft applications, but you also get an application yourself, and all the work is overseen by somebody who is a patent attorney and is allowed to practice before, or patent agent who is allowed to practice before the Patent and Trademark Office. You can see the schools that are in California that are participating in this program. We also have a number of patent and trademark resource centers where you can come and do patent searches, see what's out there, get information about trademarks and things like that, and they're all around the country. So, if you go to our website at uspto.gov/ptrc, you can find one near you and potentially obtain additional resources that way as well. We also have an inventor's IP awareness assessment, and this is something that helps you figure out what sort of IP you may have, and it's just something that is worth taking a look at and getting an idea if you might be lacking in some IP, or if there's an area of IP that you want to pursue further and potentially obtain more protection on. So one of the things that you do get for as a small inventor, oftentimes you will qualify for microentity status, which gives you a 75% off most patent fees. You can see the provisional application is, right now it is $70 to just establish your filing date. So that's hopefully not that big an expense for small businesses, and that's one of the reasons why we did it. Is to be able to help new inventors who don't have a lot of resources to sort of get the process started. There are certain requirements, and you can see those below. You have to be a small entity, so less than 500 employees. You can't have filed more than 4 previous patent applications. There's an income requirement, and you are not under an obligation to give your patent to somebody else who would not qualify for microentity status. And the same thing is if you need to get a patent quickly, we do have a program called Track 1 to essentially get your patent to the top of the examination queue. And if you're a microentity status, that also is the fees are also 75% off. And I think microentity fees right now are $500 for Track 1, but I'm not 100% sure about that. And again, we have plenty of resources from the USPTO to help you get started in terms of looking at getting patents or trademarks. Admittedly, most of these are patents, but the Trademark Assistance Center and help videos are also very, very nice if you're trying to do it yourself in terms of trying to file a trademark. And also you can see the helpline number on this there, which is 1-800-PTO-9199, and you can go to uspto.gov and be able to find all of these as well. So thank you very much, and I'll open the floor for questions.
Well, great, thank you, Ming. And we do have some time for some questions for Ming. So if you have some, please enter them in the question box. And while I'm at it, before we're waiting for a few questions, more questions to come in, if you will sign up and do the survey that is going to be emailed to you after the event, we will provide you, if you want, a handout, a PDF handout of the presentation today, and a couple of the materials that were left in our office when we conducted this workshop here in downtown Bakersfield last week. So be looking for the survey and give us an idea of what you'd like to hear in the future and some other things that are happening. So a few questions to start with here, Ming. Someone stole my trademark, and by that I believe they are mentioning that they have a national claim, didn't trademark their business name, and the party is not using it at this time. Do I need to sue to try to get that trademark back?
Well, that is a bit of a legal question. So let me try to answer it as best as I can without giving legal advice here. There are certain marks you just by using your name in commerce, you do get certain rights attached. One of the classic cases that I learned in law school was about a Burger King that had opened before Burger King was the fast food chain was national, and because they had opened before, they actually had some common law trademark rights to the name Burger King in the particular area that they operated. So the answer is that it does depend on the facts, but at least with Burger King, the small company, they actually won the case and had a 10-mile radius where they could use the name Burger King. But in terms of the actual question involved, that is very fact dependent, and unfortunately I can't quite answer that.
Our next question, thank you for joining us, Roger. If a patent was filed in a foreign country, can you file it in the US?
Yes, you can. There are certain requirements that go with it. In general, if you filed in the foreign country, they might be able to bring it in through what's called the Patent Cooperation Treaty. And basically most of the countries in the world are signees to it, which just tries to streamline the ability for somebody to file from a foreign country into the US and from the US to foreign countries. There are certain requirements, like the patent application has to be published after 18 months, and you have to do what's called enter the national phase. So you have to file in the foreign country within 30 months of the original filing date, and certain other requirements like that. But it is definitely possible.
Okay, great. What are the costs associated with filing a PTC protection or the international patent protection specifically for the European Union?
That varies quite a bit, actually. It depends on where you're going in, what countries you're going to be filing in, and how much work you have to do potentially in translation and whatnot. I know that when I was at Amazon, when we were filing in some of the European Union countries, translation fees were a fairly significant portion of the cost of the application. But it really does depend on how many countries you're looking at and what their requirements are. I would say for a big company, you're looking at potentially per country for Europe in the range of maybe 30,000 to about 100,000, depending. So it is pretty significant.
Great, thank you. Lori, thank you for your question. Can you explain maintenance fees for patents? Are those from USPTO or actually fees charged by patent attorneys for just foreign filings?
Sure. Yeah, maintenance fees are like are basically that. They are due, I want to say 4.5 years, 7.5, and I think 10.5 years after your patent's issued. And those are just paid to the PTO to keep your patent active. So if your patent is, something that you find to be valuable and something that you feel that that you want to keep going, those fees are actually paid to the patent office to keep your patent going. They're not charged by the patent attorney, and they're not for foreign filings.
Great. What is a method patent?
I've never heard that term before. So
M-E-T-H-O-N, method patent.
Maybe method.
Oh,
maybe?
method. Yeah, typo. Method patent.
Yeah. A method patent is a patent that covers a way of doing things, so a process. So a method patent is basically the steps that you would go about to do something, or to create something, or to accomplish something.
Great. Going down through. I'm going to try to rephrase this a bit. But we have an individual who's looking to do a patent on a rewards program.
Mhm.
And instead of, say, like some other program, like a gasoline rewards program that is something similar. So I think the question in here is, I'm thinking about filing a patent on something that is only a slight variation
Mhm.
from that existing patent that's existing. So how do I go about that, or can I do that?
Well, you can. You can, as long as it's new. You should be able to file for a patent. What goes on is then when it gets to an examiner, the question becomes, would it potentially be obvious in light of things? So if something would be obvious to what's called one of ordinary skill in the art to make a modification, then potentially you may get a rejection on that patent. So it really does depend on the idea and whether sort of the legal standards, again, to one of ordinary skill in the art. So with somebody who knows the area decently well, make the change to go from this to this, and if so, then potentially you may have an issue getting a patent. If not, then you should be able to get a patent. And I think I have to sort of leave it at that level of generality.
Thanks, Ming. Next question. Can you differentiate between a service mark and a trademark?
Yeah, so a service mark basically identifies a person who provides services. So if you're potentially, I don't know, doing house cleaning services or mechanic services or things like that, those would be service marks, whereas a trademark really identifies a good. So if you're selling a mop or you're selling a car engine, then that would be a trademark.
Next question is, can you please provide some simple test for the obvious legal standard? Simple and obvious legal standard? Good luck with this, Ming.
So short answer, no, there is not a simple test for the obvious legal standard. Basically, it really is a question that you would just be asking yourself. Generally, if you're an inventor, you would have an idea of sort of what people know in that area, and you'd go, would somebody knowing these things have come up with what I came up with? Would it be just something that they would just do naturally? That's probably the best way I can put it in terms of simplifying it down.
The next question borders a little bit on a legal question, but it is, as a small business, I realize that if I have a patent that's infringed on, I have to defend that patent. And my question is an open-ended question also, and is it worth it? And how do I determine if it's worth defending my patent?
Well, yeah, that's very much a legal and business strategy question. I would say this: it's worth defending your patent if what your competitor is doing is affecting your business significantly. If they're stealing a lot of your business and a lot of your profits, then that, I would say that definitely be a case of where it might be worth defending. If it's something that isn't affecting you too much, then maybe it's not. But again, that's really a business strategy, cost benefit analysis for the business to make.
Okay, great job, Ming. Appreciate it. That'll do it for today. What I want to just reiterate is that if You received the survey to please fill out the survey and put on there that you would like a copy of the presentation today. We will send you the slides and some of the other materials that were actually left behind by USPTO at a seminar held here in Bakersfield last week. So please do that and we will get those to you. Just to mention, we do have our next webinar that's going to be actually a live stream that's hosted by Google during US Small Business Week. Ironically, it'll be during our regional awards ceremony, so that'll be kind of nice. Some other additional resources that I'll just mention real quickly while I have a moment is CSU Bakersfield is part of the Blue Tech Valley program. Blue Tech Valley is a water, energy, and technology program out of Fresno State that does a lot of services in this area and has a lot of resources. And if you want more information on their programs, please contact our office. And that's a wrap for today. So for Ming Shui and our producer Elizabeth Hamlin, I'm Kelly Bearden. Thank you for joining the webinar, and we'll see you in a couple of weeks. Have a great day, everybody. Bye-bye now.